Happy Saturday evening, everybody, and thanks for joining me on my YouTube Live. I'm so excited to be here. I've got my moderator, Mitchell P., who will be making sure everything's good on this stream, and I already see Margot's online. Thank you so much for joining, and for all of those who watch the recording afterwards, thank you for watching. Tonight is going to be a very special night. I'm going to be talking with Senator Kim Pate about what is a crisis in Canada, the mass incarceration of Indigenous women. But I thought I might set the context before I bring the senator in about what the actual issues are, because not everybody is aware of how awful things are here in Canada for Indigenous women, especially in an incarceration context. So the incarceration of Indigenous women, the overincarceration isn't even like a good word. I think when Senator Kim Pate says it's the mass incarceration of Indigenous women that continues to get worse, I think that's really where we are. I also think it's important for people to understand that we're having this conversation in the context of Mi'kmaq History Month. I wish I was back home in Mi'kma'ki for all of this, but I'm on the traditional territories and the sovereign territories of the Mississaugas of Scugog tonight. And, over-incarceration, mass incarceration impacts us all. But how this relates to Mi'kmaq History Month is something that maybe younger people might not be aware of if you don't study criminology or law, for example. It's very important to remember that one of the very first royal commissions on these kinds of issues was the Royal Commission on Donald Marshall Jr. prosecution. Looks like the slide got cut off there, in 1989. And he was wrongfully arrested, charged, prosecuted, and incarcerated for a crime he didn't commit. And he spent over 10 years in prison. And they ended up doing a royal commission. And to make a long story short, they came to the conclusion that everybody in the system failed him. The cops did, the lawyers did, his own lawyer did, the judges did, and that it wasn't until his appeal was overturned finally that he managed to get any justice. And the root cause of that, the Royal Commission found that it was because he was Native. It was because he was Mi'kmaq. And that's what these issues are all about. It is ongoing racism, part of Canada's genocidal policies to basically institutionalize Indigenous peoples instead of addressing all of the reasons why police confront them, all of the reasons why police target them. This chart is from Statistics Canada in 2018, and of course it gets worse every year. And it shows, if you look at the top line, depending on whether you're watching this on your phone or iPad or PC, the top line, which is orange, shows that over the years since 2008, the incarceration rates of non-Indigenous peoples have been going down, but the incarceration rates of Indigenous peoples steadily goes up, just continues to go up. And this is, keep in mind, this is just from 2008 to 2019. Even before that, the incarceration rate of Indigenous peoples was recognized as a crisis. When you look at all of the different, they call them offenders here, but we don't know because many of them are wrongfully incarcerated. But those who are in prison, the prisoners, you'll notice that the numbers of people. So I guess turquoise line says that the number of white people in prison continues to go down over time. The number of Indigenous peoples overall continues to go up. Visible minorities stays relatively even, a little bit of up and down, and then some others. And we don't know exactly who they're including in all of those. But you see that the marked incline is for Indigenous peoples. Now, if they were to separate that out, for example, you would see Indigenous women much higher levels. So here's a much easier way of looking at it. Over the last 20 years, this slides from the Office of the Correctional Investigator. You go from 17.5% and now we're well over 30% of Indigenous peoples who are incarcerated in federal institutions. And Senator Kim Pate can explain a little bit more about that and what that means. And keeping in mind, this is just the federal situation. That's not even the provincial situation. Now, you've got women in custody since 2012. You see, again, non-Indigenous women were plateauing for a while, but now have gone down markedly. Indigenous women just continue to go up and up and up. These are the statistics. So you know that this isn't political rhetoric. This isn't something that we're making up. These are the real statistics that come from Canada's own Office of the Correctional Investigator and other institutions like the Canadian Association of Elizabeth Fry Societies, John Howard Society, and others who study this crisis. Now, here is looking at what it is for Indigenous women. We know now, I believe, and Senator Kim Pate can correct me in a few minutes, that Indigenous women they could be 98%, they could be 80% in provincial jails or institutions. And at the federal level, you've got them. It was 30%, then it was 35, then it was 40, then it was 42. And now I believe it's exactly half, or maybe 51%, maybe a little bit over. So that's just like, at what point, especially considering Indigenous peoples overall in Canada make up about 5% of the Canadian population. So to be 50% of those women in federal institutions is just unbelievable. But Senator Kim Pate always reminds us that as bad as it is at the federal level, if you just take some examples of prairie provinces like Manitoba, Saskatchewan, and Alberta, here's an example. You've got Indigenous women in Edmonton who keep going all the way up, 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 up in terms of their incarceration rates, sometimes as high as 70%, and Indigenous men aren't far behind. If you look at the situation in Saskatchewan, you know, you look at Indigenous peoples in federal jails, 65%. Now, this was from a few years ago, but in provincial jails in Saskatchewan, it was 76%. All of those rates now, we know, have gone up in that province and continue to go up. And it does for youth corrections as well. So we know that at least 50% of all of the kids in youth corrections are Indigenous. But if you look at certain provinces, Indigenous girls are almost 100%, like in Saskatchewan, and Indigenous boys, 92%. So we're not just incarcerating adults, we're also incarcerating the Indigenous children, in fact, because they're not adults yet. Here's a slide that shows Saskatchewan, the Indigenous youth correction centers. You know, overall, you've got Manitoba, Saskatchewan, BC, Yukon, NWT, and Nunavut, who all beat the national average, and the national average isn't good. So this was at 60%. So it's even more than the 50%. And like I said, these continue to grow. These are literally astronomical numbers. And I'm just going to leave that there for now because I want to bring onto the stream my good friend and hero and warrior and champion for human rights and Indigenous peoples and Indigenous children. I mean, I can't
That's you.
about her. And she hates it when I say that too. But Senator Kim Pate, she is an amazing woman. She used to head up the Canadian Association of Elizabeth Fry Societies, and they represent, you know, or advocate for Indigenous women in all kinds of incarcerated institutions. Before that, she worked for John Howard, so she worked with men in those institutions. And now she's in the Senate. But here's the great thing. She's an independent senator, which means she doesn't have to do what the Liberals say or what the Conservatives or NDP or anything else like that. She can follow her heart, which is why you see her taking senators to prisons so that they can see for themselves what it's really like. And so, Kim, welcome to this live. This is like an urgent issue, which is why I wanted to broadcast and blast this information as far and wide as possible, because we also have legislation pending and there's a potential opportunity to try to reduce some of this incarceration. But I'm wondering if you can just start out by speaking to, like, I mean, I went very quickly through the slides, but the state of affairs, like how long this has been a crisis.
Sure. Thank you very much. You did a fabulous job of outlining. So in 1999, the Supreme Court of Canada in the Gladue decision said the mass incarceration or overrepresentation of Indigenous people in prisons was a crisis. That's when they were at 17, 18%. Women were already in the high 20s. Now, as you've already mentioned, women are now half of the federal prison population, 75% and higher in the prairie provinces, in the federal prisons, and even higher than that in the provincial jails where they're so federal means they're serving 2 years or more. Provincial means they're serving under 2 years or they're awaiting trial, and even worse in youth jails, which means the trajectory is something that's coming up. And as the Missing and Murdered Indigenous Women and Girls Inquiry clearly pointed out, the very same issues that give rise to women being more likely to be disappeared, murdered on the streets are the same issues that give rise to them being the fastest growing jail population in this country. And that is its histories of past abuse. Often they're either they're survivors themselves of residential school or first or second generation. Many of them have had histories of abuse. Many of them have been removed from their families and communities and lands and seized by the state, put in child welfare, so-called child welfare systems, and have ended up in those systems in the very same units, beds, institutions sometimes where young people who are also criminalized are placed. And so we know from all the research that's been done, we know from the lived experience of people that if you end up in care, you're also more likely to end up criminalized and in custody. Because you're often disconnected from folks, you don't have the same supports, you're often left in poverty, you don't have the same access to education and healthcare and all of the things that create a more equitable starting point. So we see people in that position. And as you've mentioned, right now, the government has indicated through a piece of legislation they've introduced, Bill C5, it's a government piece of legislation. They characterize when they ran for government in 2015 and now in every minister's mandate letter, reconciliation is part of the mandate. And as you know, just a week and a bit ago, we were observing Reconciliation Day and or Orange Shirt Day. Basically, everybody was, or not everybody, but most everybody was saying, yeah, we're committed to reconciliation. So what is that action? And the government has introduced this bill. And they said part of the objective was to repeal mandatory minimum penalties that have been brought in that drive guilty pleas for people. They drive people to, Crown prosecutors to push and encourage them to do plea deals. And that's, you've already mentioned Junior Marshall, Donald Marshall. I mean, he was amazing that, I don't know if I'm sure because he's from Mi'kmaq as well, but his whole work after he got out of jail was working for people he did fishery rights but he also worked with kids, and that's how I first met him. He was working with young people and really trying to help get them out of that situation. So when Bill C5 came along and the government said, we're going to repeal mandatory minimum penalties and we're going to reduce the numbers of Indigenous peoples and Black people in prison. So I said, great. And then I looked at which laws they were repealing, which mandatory minimums. And I thought, hang on, you're not repealing the ones that contribute to the fastest growing prison population, Indigenous women being in prison. You're really not going to reduce even the numbers of those of African descent as well. You're going to reduce a little bit in the provincial jails, a little bit in the federal, but only if the people have only been convicted of those offenses that are being removed. And we know that one of the issues is that often people are charged with multiple offenses for the types of mandatory minimums that they're repealing. So the end result is we're not going to see a change in the prison mass incarceration of Indigenous and Black people because of this legislation. And so a number of us are working on an amendment that would help move us in that direction. It's not perfect. But it would be an amendment that would say for every every mandatory minimum that the government leaves on the books that they are not repealing, that instead of leaving a patchwork, because a whole bunch of them have been declared unconstitutional already in parts of the country. So you might be in Alberta and a mandatory minimum applies, but then you might go to BC and the mandatory minimum doesn't apply. So that goes completely against a fair process as well. And so the provision we're talking about is one that would say that any of the mandatory minimum penalties that Bill C5 does not repeal, judges have the authority to do their job, to weigh all of the evidence and to look at it. And as a number of judges have said to me, the fact that the mandatory minimum penalties exist and the government says they want to address over-incarceration of Indigenous and Black people, and yet they've completely left the majority of the mandatory minimums that contribute to their incarceration in, and it means then that if you have a mandatory minimum penalty, Section 718(2)(e), often referred to as Gladue principles, can't be applied. So they're making judges break I would say they're making judges break the law by not being able to do the job they're supposed to do of weighing all of the evidence, looking at what's right and proportional and fair for what's happened, who the individual is, what they did, who they did it to, and what the circumstances in the community are. And so instead, many folks are saying, oh, well, we don't want to appear soft on crime. And really, this bill is not soft on crime. This bill, though, is continuing to allow for the jailing of more Indigenous mothers and the seizure of their children, which will not increase public safety. So anybody who thinks it's soft on crime, one, has not looked at what the impact is going to be, and is actually saying, this is what they're actually saying, is we want to jail more people, particularly Indigenous people, especially Indigenous women, and seize their children, and somehow that will make Canada a safer place. Nothing could there. And so if they're saying that, I say to everybody, when you hear that, ask for the evidence. Show us the evidence that that's actually going to achieve public safety. It's ridiculous. It's not true. And it's not going to, the bill right now is not fit for purpose. And so we're trying to help move it along. Even better would be if all of the mandatory minimum penalties were repealed. But this kind of mechanism exists in lots of other countries around the world. And so there's no reason we shouldn't have it in this law. So in the Senate, we're going to try and get it passed, and then it will go back to the House of Commons. And so all of you listening have a role, because if you call your member of parliament, the senators from your areas, and if you need a list, let us know. They're all listed. Then and let them know that you want to see, at the very least, this kind of amendment. So an amendment that allows judges to do their job, and any mandatory minimum penalty not repealed, judges can do their job and not impose it if it's an appropriate circumstance.
And don't think for a second, anyone who's watching or listening now, or the recorded version, that your voice actually doesn't count, because it really, really does. I have testified before Senate and parliamentary committees, and I've had the question, well, no one else seems to be very concerned about it. So we have an opportunity to send an email. An email is quick, it's free, and you don't even have to be an expert in law. You can just say you must remove mandatory minimums, and to address this crisis. And I would argue, in addition to Indigenous people, it also hurts other people who are facing the criminal system because of reasons of poverty or mental health, or because, like you said, they're from the Black community. Anyone who's marginalized, racialized, targeted, neglected, or abused in society, mandatory minimums don't work. And so for anyone who doesn't understand what Gladue is, Gladue was a case, and I'll let the senator talk about it, but decades ago, where the Supreme Court of Canada recognized that the over-incarceration of Indigenous peoples back then meant that we should take into account the lived experiences of Indigenous peoples, the colonial context, the reasons for them being in that situation, and where possible, look for alternatives to prison. So you would think that once that case came out, I mean, that comes from Canada's highest court, Supreme Court of Canada, that you would see at least a gradual reduction. Instead, we've seen the crisis, triple at this rate? I mean, it continually goes up. And so now, one of the issues about Gladue, we thought that if people were taking into account the lived experiences of Indigenous peoples, could be residential schools, could be foster care, 60 scoop, could be homelessness, situations of abuse, that once they did enter the prison system, that they would be afforded all of the supports and all of the care and considerations for, lots of things. But Senator Kim, I understand that it's actually being used in the reverse. So we're not just talking about the original incarceration of people. What happens once you're in there, all of the disproportionate things that happen?
Right. So people are being charged. You're more likely to see someone who's on the street, has known to the police, so because they were in child welfare. So if you're already known more to the state authorities, you're more likely to be criminalized. That's just a reality because you come to the attention of the authorities more.
Mhm.
We also know that systemic discrimination and individual discrimination exists in the form of who gets stopped, even if they're not on the street. And we know from carding examples, we know from frisks, all of the research that's been done, that it's more likely to be people who are racialized, and then they're more likely to be charged. They're more likely to be charged with more serious offenses. They're more likely for those charges to continue. They're more likely to be convicted because the racism continues and the misogyny continues through the system. And they're more likely, once they end up in prison, to be classified as higher risk. There's been a fair bit in the media recently about and certainly in the courts, about the systemic bias and discrimination in the classification system. So that means, in fact, when you're talking about women, Indigenous women, they're about 70% are likely to start in maximum security, which means they also have less access to programs and services, which means they're less likely to be eligible for parole on the dates that they're supposed to be. It means they're less likely to have the support and structure and assistance to go into the community. They're more likely to be released at the end of their sentence without those assistance. And so it really is something that it's a compounding discrimination that makes it harder and harder. And then when they get out, it continues, of course, because then they have criminal records, and so maybe difficult to find jobs, to get their kids back. If they're many people don't realize that about 90% of the kids of women who go to prison end up in the care of the state, versus about 10% of the children of men. Now, it's not good for any of them, but why is that? Well, because often the women are the last ones left standing with those kids. And when the men go to prison, whoever has been caring for the children up until then usually continues on. Women, many of them are sole supports of their children before they go to prison, and the kids end up, even if I know so many moms who set up alternate arrangements, but if they don't have resources, which many of them are living in poverty and struggling to make ends meet before they go to prison, oftentimes those arrangements break down because people just can't afford to keep it up. And we don't prioritize keeping kids in their homes, putting resources there. The resources go more into taking kids away. So the discrimination continues on. And as you and I have spoken many times before, I don't refer to Section 718 2E as Gladue factors. Everybody knows them as that because that was the case that went to the Supreme Court of Canada about 5 years after they were put into law. And it went to the Supreme Court of Canada in the case of Jamie Gladue, but Jamie didn't benefit from them. And what happened to her is a really good, horrible example of the intersection of the misogyny, the racism, the class bias, because it went to the Supreme Court of Canada as a case of the judge not applying 718 2E to her because he said she didn't live on reserve, because she lived in an urban setting. Totally missed, though, that they also mischaracterized her situation. They characterized her as a jealous wife who'd stabbed her common law husband because he was having an affair. He had beat her up. She was 19, pregnant by her second child. He had broken into the unit
Wow.
where her sister was living with her father and other younger siblings. He had raped her sister, had come back, beat Jamie again. And when she stabbed him, he was trying to get back in through the front door of the unit where her siblings were and her sister was. Now I ask you, does that sound like a jealous wife? So you see the racism at every level, even in the way the Supreme Court of Canada, well, the Supreme Court of Canada just repeated the facts. It's not them who made up the
Mhm.
story. But even the fact that as it went up, we still weren't addressing some of those issues is exactly why, as awareness has grown, as we've had the TRC, the Missing and Murdered Indigenous Women and Girls Inquiry, and people are more aware of those links. It's so important to apply Section 718(2)(e) in all cases, especially Indigenous women who are more likely to be charged for responding to violence first done to them. And none of those mandatory minimum penalties, none of those offenses that carry the mandatory minimum penalties are included in this bill. And so it's not going to impact them. And so we need judges to be able to look at all this context and say, hang on, in this case, you may have charged her with murder, but really, but for the day, she would have been the victim and might
Yeah.
very well have been the person murdered. And so
Yeah.
that whole context is so important for a judge to be able to take into account. And with this bill right now, and with this bill the way it is without the amendment, a judge couldn't do that.
And so, for the people who are listening, you don't have to be a lawyer, you don't have to be a criminologist, you don't have to be an expert in anything to just understand the basic principles of racism. So look at Cindy Gladue. Not only was that racism, but the misogyny to even label a woman who's a victim of abuse and trying to protect her sister who was raped as a jealous wife. Like the misogyny and the racism go hand in hand, and it's unbelievable. But so here's the thing. Kim is talking about mandatory minimums. That means when you commit a certain crime, the judge must give you at least a certain sentence. So it could be a year, it could be 2 years, it could be whatever it is. No discretion. No matter what the circumstance was, it's an absolute mandatory minimum. Now, compare that mandatory minimum to what the Supreme Court of Canada said in the Gladue case, where they literally instructed all of the judges all over the country, where appropriate, find alternatives to prison, given the horrible context many Indigenous peoples have lived through, their lived experiences. So the Supreme Court of Canada, which is Canada's highest court, has said alternatives to prison. There's a crisis here. Now you have legislation that says mandatory minimums. So the judges can't do that. They can't. Like, it's literally in the law. So that's why Senator Kim is doing whatever she can to talk to whatever audience she can. She was on my Twitch stream this week. She's been like, we do TikTok lives, we do everything, because issues around prison justice or prison injustice simply doesn't get enough attention in Canada, and the government benefits from that. And it's important that we all take up that call to tell Canada mandatory minimums. Wait a second. I thought Supreme Court of Canada said to reduce and find alternatives. And then you think about what Senator Kim said when she was opening. What did the Truth and Reconciliation Commission say about the over-incarceration of Indigenous peoples in general? And who are the ones that are incarcerated, right? We know from the latest statistics I looked at was about a fifth of Indigenous peoples in prison came from the residential school system. Even more came from families who are from the residential school system. And 2/3 came directly from the foster care system. So basically, Canada's genocidal laws and policies used to institutionalize us and try to assimilate us, and the impacts of it are now being used as reasons to incarcerate us, and they're not doing anything. So you've got this terrible pipeline of an Indigenous woman goes to prison, so her kids end up going to, foster care. Once the kids enter foster care, if they're not sexually abused or physically abused or neglected, and not all foster care systems are like that, but for Indigenous peoples, it's disproportionately like that, they're statistically more likely to end up in jail than to even graduate from high school or end up homeless or end up murdered and missing, you name it. So basically, Canada knows, okay, here's the formula for mass incarceration. This, and this. We're not going to erase any of these things. And, Truth and Reconciliation Commission, Donald Marshall Inquiry, Murdered and Missing Indigenous Women and Girls have all said, you must address this. And correct me if I'm wrong, but didn't the National Inquiry into Murdered and Missing Indigenous Women and Girls also say you need to address this over-incarceration and mandatory minimums?
Yes, they did. Both the TRC and the Missing and Murdered Indigenous Women and Girls Inquiry did. And we've introduced, as you know, a report really as the government was looking at wrongful convictions. You started with Donald Marshall.
Yeah.
He was one of the first and only racialized people, Indigenous people, to have their cases reviewed. And it was only because, a few dedicated folks really took up his cause. He was being ignored up until then. And the report that the Justice Harry Laforme and Justice Juanita Westmoreland Traore put out earlier this year showed that, in fact, in the last 20 years, the government of Canada has convicted or has reviewed very few wrongful convictions. And of the people who have been exonerated in the last 20 years, there were 20 people, all men, 18 white, 1 black, 1 Indigenous. So, even the review processes that have been put in place haven't addressed this. And so, yes, both the Missing and Murdered Indigenous Women and Girls Inquiry and the TRC called for an end to the overrepresentation of Indigenous people in prisons, and called for a whole bunch of other measures to assist in child welfare and the like, but also called for an end to mandatory minimum penalties. And if not an end, then the type of amendment that we're trying to make, which is what the Supreme Court of Canada also recommended in a case called Lloyd. Chief Justice McLaughlin recommended that if they're not going to repeal all the mandatory minimum penalties, they should do what, and actually New Zealand just did it in August, that they should introduce this kind of mechanism that allows a judge in a structured, use their discretion, do their job the way they're supposed to, and in a structured way, look at all of the factors and then provide reasons and not impose a mandatory minimum penalty. So that's what we're trying to see. And, some people are saying, well, we should do it for everything but murder. And my response is no. The majority of women who fight back and survive end up charged with murder. And so disproportionate number of Indigenous women, and given the discrimination in the system, they don't get the benefit of self-defense or defense of other, as in Jamie's situation, Jamie Gladue, because the law of self-defense is still applied in a very male way. That it's, the law was developed at a time when women and children had no rights. They were the property of the men who either fathered them or married them. And so the law of self-defense developed around the way men fight, in originally dueling or then barroom brawls. And so it was force for force. And so oftentimes women also, if they engage in hand-to-hand combat, literally, they end up dead. And so when a woman does try and resist the abuse, the violence, she may wait till the guy is passed out after he's just threatened to kill her. She may grab his gun when he's turned away. She may grab a knife from the kitchen. And so she's more likely to be convicted, even if she isn't charged with murder, of a violent offense and a weapons offense that carries mandatory minimum. And so all of these provisions need to be taken into account. And right now they get treated as though they are the same as someone who goes and commits, sometimes even multiple murders. And so in a few cases, in a case just this past summer, Bissonnette, they looked at, and the Supreme Court of Canada said, it is unconstitutional and it's cruel and unusual punishment. It violates the charter to sentence someone to a term of imprisonment with no hope of them getting out. Well, if you're a woman who's in her 40s, 50s, 60s,
Yes.
or even in her 20s and she's Indigenous, and she's likely to start in maximum and not get out for 30, 40 years, as the report that we did, the 12 Indigenous women show, then that's exactly what the Supreme Court of Canada was talking about. And the last time they looked at the mandatory minimum for murder was a long, long time ago in a case called Luxton. And at that time, the Supreme Court of Canada said, well, we think it might be unconstitutional, but there's a thing called a faint hope clause. Now, the faint hope clause was put in at the time that we got rid of capital punishment because the murder sentence was increased. The mandatory parole ineligibility period went from 10 to 25 years. And so, but at the same time, the government said, and in fact, prison guards, police officers, everybody agreed, wow, life imprisonment is already long enough. People they don't get parole unless they've earned their way out. You heard about all the discriminatory attitudes and approaches and why people don't get earn their way out. So they put in a provision that said at 15 years, if someone has done really well and they can apply, there was a 4-step process. You had to go to the court, you had to go back to a jury, you had to go. So it was a long process that then they could apply, possibly get parole and eligibility reduced. Well, that was repealed in 2011, 2012. And so now there is no faint hope clause. So the last time Supreme Court of Canada looked at even murder, they said, if we don't have that, it probably isn't constitutional. Now we've got Bissonnette saying, if people have no option, no possibility of getting out before they die, then that's not consistent with the values we hold for our criminal legal system. So let's make it a justice system. And one step is to put this mechanism in and say, okay, you're not repealing all of these mandatory minimum penalties yet, but while you decide which next ones you do, whenever, and we don't even know when that will be, then in the meantime, this provision has to be there, and judges have to be able to do their job and not be handcuffed by a law that says, oh, in this mandatory minimum, you don't have to worry about that anymore. But in all these other ones, you're still stuck.
I just can't imagine. So you take a scenario where, you and I have talked about this. A little girl goes to residential school. She's sexually, physically abused, neglected. She comes out of residential school. She has kids of her own. Maybe she's in an abusive relationship, because we all know if you were abused in the past, there's, sometimes a more likelihood that you'll be abused as an adult. And then she defends herself from being murdered by her husband because no one's enforcing court orders, no one's giving her any protection, no one's listening to her, ends up in prison because she's had a life of violence. She's the one that's being punished for that, in addition to losing your children. Like, I can't imagine. I think that's got to be the most horrific thing possible. And not just lose your kids, but in many cases, not even being able to see them because the family can't travel or the foster care system won't let them. And knowing that once those kids enter foster care, maybe her daughter is going to end up in the same scenario. And the fact of the matter is we all know it's a formula. And all we have to do is take out the variables that do that, right? So you think about, like, on its simplest level, what are the reasons, right? Abuse, neglect, the failure to protect people's human rights, abject poverty, not having social supports, mental health supports, family supports. And you think, okay, well, if those are some of the root causes, probably the majority of people in prison, those are the root causes. Why wouldn't we just provide those social supports? And one of the initiatives that you're also trying to promote is guaranteed livable income or guaranteed basic income. I'm not sure what they're calling it now, but can you just talk a little bit about why you advocate for that so much, and its relationship, obviously, to prison and a whole bunch of other societal ills?
Right. Well, when I first started doing the work, because I was in law school still, and I was at Dal, and in your part of the country, actually, so were you, in your part of the country, and I was I was shocked. Then I was shocked, and I still get shocked by how many of the kids. I was working with young people, and how many of the kids going through the system were poor, racialized kids in that part of the country, especially Black kids of African descent and Indigenous kids. And I thought, that's not, I know, we all know that by the time any of us reaches adulthood, there's very few of us who haven't done something for which we could have been criminalized, depending on who we did it to, when we did it, who knew about it, all of that. And so I was struck by that. And as time went on, and as those, I worked with adults in part because those kids grew up and they didn't have any new chances and so I saw people who came from poverty, who came from abuse, who didn't have the same supports, didn't even have access to the same healthcare systems, dental care, all of the things that make a more substantively equal starting point, and were more likely to go to prison than they were to go to even finish post-secondary education. And so that's how I became interested in those issues, because I realized, like, if you don't start from an equal starting point, you don't have equal access to healthcare, social services, housing, clean water, education, then you're more likely to be dropped through the huge cracks in the systems and end up in the only system that cannot refuse you, that cannot say no, and that's our criminal, legal, and prison systems. And so prisons have been being used for women as though they're shelters, as though they're homeless or battered women's shelters, as though they're a place to get, a meal and shelter, shelter as in housing, as well as a place for addictions treatment. They are not treatment centers. They are not shelters. And we shouldn't be filling them with women, because every study that's been done has shown that, in fact, women pose the least threat to public safety. And if any of you listening or watching are thinking, okay, I want you to think about when you walk out and sometimes you may be fearful. Of course, we're told to be careful. Where the problem is usually put on, if you're a woman, you're told to protect yourself and you're partially responsible if something happens. But how many of us, when we walk out, are fearful of groups of poor Indigenous women who have histories of abuse, who've been through residential school, who are struggling to support their kids? No, that's not who we fear. That's not who we think is causing the greatest risk to public safety. But that's who is the fastest growing prison population, because we have taken away all those supports. So that's why I support a guaranteed livable income. It's why I support free post-secondary education, healthcare, all of the things that, as my colleagues, I'm learning so much from the guys who have been in business and banking and stuff in the Senate, because they tell me, I'm on finance committee now, and people go, "You're on finance?" And I say, well, because I want to understand, like, we are allowing all kinds of money to go out of Canada that could be tax money, could be feeding our economy, could be funding these issues. We never question how much money we spend taking kids away from from their families. We never question how much money we spend putting people in jail, when what they really need is social and economic and health supports. And if we did question that, and the few examples of where guaranteed livable or basic income pilots have been tried, we saw not just people do better financially, but the money they got, they used in the community. They contributed to local business, but it also meant they were healthier, they could eat better, they could have housing, they weren't on the streets. And so their health got better. And so we saw decreases in the healthcare system. And it's not an accident that Dr. Evelyn Forget, who's from Manitoba, was interested in this as an economist, because she saw that the majority of people coming through, when she worked in a hospital in Winnipeg, majority of people coming through emergency services were poor people and racialized, particularly Indigenous people. And that's because they didn't have doctors, they couldn't afford the lifestyle, the housing, the things that protected you from getting more serious illness. And so there was higher diabetes. There were all kinds of emergency care situations arising that wouldn't happen if we had supports for people, economics, housing, and food security. And then she also found that in that pilot, because she did all the number crunching, that the healthcare costs went down and the crime rates went down and the costs of the criminal, legal, and penal systems reduced.
Wow.
Why wouldn't we want that? And so when people say, well, we're just locking up the people who are causing harm, that's not true. We know
No.
that. And also, we can't pay for these things. Well, we are paying for them. We just are paying for them in ways that we don't often think about. We're paying for them in ways of keeping
Yeah.
people stuck in poverty. We're paying for them in ways of, price, wages that aren't and competitive. We're keeping them in terms of more drain on the healthcare system, and we're keeping them in ways like the higher costs of the criminal legal system. So we need to move in different ways,
Yeah.
and there are resources that we could be using that we're not tapping into now. And I love, not only did New Zealand bring in this kind of mechanism and they repealed a bunch of mandatory minimums recently, but their prime minister is also talking about coming out of the pandemic, looking at human well-being, not just gross
Wow.
domestic product, and
Wow.
is saying if we're going to have really a recovery for all, and we're using that rhetoric here in Canada too,
Yep.
then it has to be a recovery for all, and that means we have to put in other things. And we saw the government decided that people who couldn't work needed at least $2,000 a month. There is nowhere in this country where people are receiving social assistance of $2,000 a month. And yet that's what was deemed to be minimum during the pandemic. And so there are all kinds of reforms that I think we also have to work on. But we can start by when we've got bills like the ones before us right now, like this one, or some of the budget bills, many of us are asking those questions. So, how are we taking care of the people who right now are struggling? And as our friend and amazing inspirational leader, Cindy Blackstock, has
Yeah.
said, if they can put broadband and water on the space station for 6 people or 5 people, however many is there, how on earth can we justify that it's anything but a policy decision to not make sure there's clean water, broadband, access to these supports for every person in this country?
Exactly. So for anyone who's just joining us, Senator Kim Pate and I are talking about the mass incarceration of Indigenous women and girls. If you have a question for Senator Kim, put it in the comments and I'll put it up on the screen so that she can try to answer it the best that she can. We are talking about what is it that we can do? Oftentimes people feel so overwhelmed, like, oh, look at this mass incarceration. I'm not a lawyer. I don't work in the system. I don't know what to do. Well, she's made a call to action that there is an attempt to make an amendment to Bill C-5 to make sure that even if they haven't removed all of the mandatory minimums, which they should, that in the interim, judges will be given the freedom, the discretion to decide what sentence, if any, in certain conditions, or maybe there's going to be an alternative. Maybe they'll end up in their community because all of that is, permissible under the criminal code. So that is so important. That's a call to action. You can email your MPP, you can email the minister, you can email, senators, like you can share it all over social media. You can help share this video because it's really, really important that we do that. We have to take action. We can't just feel bad, or we can't just focus on awareness. Awareness doesn't do anything for those women in prison, right?
Mm-hmm.
It's the action that we do. And I can't imagine what it would be like for them because I have never been incarcerated. Now, the other thing that Senator Kim has worked on, she works on a multitude of things, obviously, but there's a whole bunch of different things in the whole prison and justice system that we can deal with. And one of them, I'm just going to bring it up here, is this. So her office just as in sometime this year, released a report called Injustices and Miscarriages of Justice Experienced by 12 Indigenous Women. What they're doing is they're making a case for their convictions to be reviewed and exonerated because looking at all of the evidence, there simply wasn't evidence that they did the crime that they're accused of or that they're serving time for. The caveat that Senator Kim always says is, while this report's focused on 12 Indigenous women, you could do a review of all of them, and there would be many, many more women. But Kim, what is this report really talking about? Is there a call to action for ministers, the government, or for the public to be a part of? Because I think this is really important when we think about it. These women aren't just statistics. These women are literally sitting in prison hoping that we take up the call to take action and put pressure and do something about their unjust situation.
Yeah, these women, well, one has since died, sadly, and another one, actually, not long ago, I was asked to participate in a review of her. She had asked for medical assistance in dying because she was so, couldn't cope with being locked in a segregation cell anymore. The minute I talked about the fact that the medical people had to look at some kind of hospice situation if they were going to even consider medical assistance in dying, she immediately didn't want to die. Big surprise. So the conditions are, it's grave. So the reason that we did this report was actually, it was when when Justice Harry Laforme and Justice Juanita Westmoreland Terreri were asked by the Minister of Justice to look at the conviction review process and make some recommendations. They met with a lot of folks, including David Milgaard and others who had their convictions reviewed. And I'm organized for them a meeting with these Indigenous women. And when they heard, they said, really, you should write that up. They're making recommendations, but there is no body yet. The government is supposed to be this is another recommendation or possibly another piece of legislation and or a commission that will be set up to do the reviews, conviction reviews. So they said, get this ready, because whenever that's set up, it would be great for them to take these. Now, two of the women since the Justice Minister has agreed to review their cases, and so has Innocence Canada taken on their cases after initially rejecting them. And they're listed, their initials are in there as NQ and OQ, Odelia and Nerissa Quaisons, they're sisters. And they've come forward. The others, and even Odelia and Nerissa at the time, didn't want their actual names used for their own protection because they haven't been treated fairly by the system. So we're hoping that their cases will be reviewed. But you'll also see in that report, one of the recommendations is this kind of mechanism that we're talking about, that there be the provision for judges to not impose mandatory minimum penalties when they look at all the evidence, or if the evidence isn't all produced by, whether it's because it's an inexperienced or counsel, or they're not sure how to frame it or how to get all of the information before histories of abuse and that sort of thing, that this kind of mechanism be in place. So that's why that report was done. We also did one about senators going to jail, because we also have made recommendations that the very measures that were put in place back in 1992 in the corrections legislation that were supposed to be off-ramps out of the system for Indigenous people and women in particular, and also people with mental health issues, have not been well used. And in fact, corrections has limited them so much that they've set up things like healing lodges, but set them up as jails, not as actual community-based supports for people to be alternatively sentenced to, or to be, moved out into the community. And so that's another report that we're trying to get some movement on, and really trying to get the resources into the hands of Indigenous leaders, communities, because they know what they need to keep themselves safe. And some communities are saying, well, if someone has done something, say not these women, but somebody else and has done something that's particularly harmful. And we just saw that coming out of James Smith Cree Nation, that the community may not want that individual in their community, but they don't want them just locked up and having no supports. They want supervision, they want community. And so some communities are talking about, how do we partner with others, so that, if I'm not welcome in my community, can I go to your community and try and make amends still with my community, but in the meantime be
Mhm.
not just locked up, but actually contributing in some other helpful way, and being held accountable, but also doing that. And so those are some of the things we're working on as well, to say, it's just not good enough to say, let's just lock people up, throw away the
No.
key. Those people most times at some point will come back to the community, and we don't want them coming back worse. We don't want
No.
them coming back without any means of supporting themselves and potentially posing a risk to the public. Then we want to actually create the supports that,
Yes.
they can be held accountable, they can pay back if they can. Not all crimes can be, someone's gone. If a life is
Yeah.
gone, you can't bring that life back. But there are ways people can be held to account that can allow them to contribute to the community, and and
Mhm.
get on with their lives, and not just go to be punished forever, in the hopes that somehow that will teach them something. In every other sphere, we've gotten rid of punishment for punishment's sake, and whether it's child rearing, whether it's and even confinement, for animals. We've thought of all kinds of creative ways, and it's time for us to do that for people as well.
All of it. I mean, the solutions are all there. We could never have another inquiry, commission, review, coroner's report, any of those things, and we would literally have all of the solutions before us. So, to my mind, this is about making a conscious policy choice. So, remember the analogy that I used on the Twitch stream about Dr. Cindy Blackstock's case, and how the evidence they used to win their human rights case for Canada discriminating against First Nations children in foster care came from Canada. Canada did its own research, its own studies, and said, oh, look, the gross and discriminatory underfunding that we provide to First Nations and Child and Family Services is one of the causes of the high rates of apprehension. And they never, ever made a conscious choice to stop that, because presumably, if that's one of the major root causes, oh, well, then that's easy fix. Here, we'll just appropriate more money from Parliament to provide child and family services and deal with all of the kids in foster care. And so you've got the same, you've got the same scenario here. They have a choice to make. Clearly, the House has already made the choice that they're not going to remove all the mandatory minimums, but the Senate is now advocating, or at least you and some of your colleagues, to do that, because otherwise they're making a choice to allow mass incarceration. They're basically telling society, we're okay, it's only Indigenous women and girls. They are making a conscious choice to ignore the fact that that's going to result in more Indigenous kids going into foster care and suffering and living on the street, or going into youth corrections or prison themselves. It's a choice that they're making. They're choosing to contribute to homelessness. They're choosing to contribute to all of these things when they know what the solution. They know they're the cause. Well, be the solution. So, for all of you here, follow Senator's call to action to contact these politicians, because we need to remind them, you are making a choice. You have control over this, and you're making a choice. You're okay with murder and missing. You're okay with mass incarceration, because we know it's only going up. If they don't do something radical, or I don't even consider removing mandatory minimums as even a radical thing. It's like a bare minimum so that we're not violating laws. They just need to be reminded that these are choices that they're making that have devastating results. And it's why Canada was found guilty of historic and ongoing genocide. So are they going to continue to be responsible for and liable for ongoing genocide when they have the power? They literally have the power to stop that. I hope they do. And I just want to, say thank you to everybody who's here, to Margot, to Mitchell, to Lost Sue, to Wendy, to Thor, to who else is on here? everybody who is watching, everybody who's participating, Rila is on here. They're saying that they agree. They're happy that you came on here. They're sharing some of their experiences. For example, La Sue is saying, I can't even visit my mom in Winnipeg without getting stopped by the cops every time I step outside of her door. La Sue also has a question. If any Indigenous person, is it possible to have our people removed from their courts and do some kind of alternative justice? And I mean, I would say, of course, that's already happening. But Kim, isn't that possibility already there under the Criminal Code and Corrections Act and everything for us to actually do that?
Well, there are provisions that allow for special circumstance courts, and there are some Indigenous courts. Unfortunately, in many cases, it's only certain offenses and only certain level of security of individuals that can be referred there. So, contrary to what we think, and in fact, there's a chart in that report that Dr. Palmater put up. Pam, sorry, you're an amazing scholar, educator, everything. But there's a chart that shows everything that we've tried to do to indigenize the system has resulted actually in more people being put in the system because it's widened the net. And so what we really need to be doing is in those courts demanding that communities take control of them and say, this isn't something where the system can say, no, you can't send anybody who's done something serious, because if we're willing to work with that individual, then we should be permitted to take that case through instead of having the gatekeeper be, again, basically the non-Indigenous system to decide what can and cannot go there. So we've been moving in, at least in thinking in a good direction, but we haven't practically got there because it really is just the surface. And I would argue that many of the people who end up in those courts don't need to be in court at all. They need to have supports in the community first and foremost. So we really need to be focusing on much bigger change and saying, when I worked with young people at one point, we argued that instead of doing more diversion programs are great, but it's mostly the white, when I was doing them, it was mostly the white, fairly well off kids from fairly well off homes who were getting diverted. And it was very rare would it be a kid, from who was in care, was racialized, particularly Indigenous, very, very rarely. And so we ended up saying, okay, I went to the police, I went to the corrections folks and said, I want to work with the kids that you have identified as the people who are most serious. And they called them serious habitual. If you can imagine calling a kid a serious habitual offender, but they did. And so I said, okay, I want to work with the top 10 in that group. And what we did was we started working on the issues of how they ended up there. And these kids were all kids who were projected to end up in the federal penitentiary system. 3 of them still did, I'm sad to say, but 7 of them didn't. And, if that's all it took is 2 intensive years of working with those 10 kids, imagine what we could do with more resources, more supports, more communities doing that kind of work. And so, sometimes people say, oh, it's a great philosophy, Kim, that you're suggesting this. Well, no, these are people that I have walked. I mean, the 12 women who are in that report are women I've known 20, 30, one of them 40 years. And she was one of those 10 kids initially. And she was one of the ones that ended up briefly in a penitentiary and was labeled a dangerous offender at the age of 21. But now has been out 23 years and counting. And I have no doubt will never, ever be back in the system. Once she got mental health support, she had schizophrenia, and she got the medication, she got the housing, she never looked back. But first she went through, quite literally hell of dealing with all that, being on the street, having to sell her body to make ends meet, all kinds of things. And so and being labeled a dangerous offender in the process of it. And so she's one of the ones whose cases I think also needs to be looked at. But there's lots of
Yeah.
really good. So it's a big issue, but there are also lots of very practical,
Yeah.
shorter steps people can take. And so that's why when, you and others have challenged people like me to say, okay, what is the action you're going to take? These are
Yes.
some of the action points we can take.
Literally, I mean, that's how, people are asking, how can we support you? I mean, we're talking about at the highest level, address the root causes, to prevent it in the future. We've got to do prevention, and then provide the supports for people who are caught up in the system now. We can't forget
Yep.
about people who are there now, like you and I were calling during the COVID pandemic to decarcerate these women and provide supports for their families. And some people were saying, oh, that's ludicrous. How can we just decarcerate women? And wasn't there a famous world leader who did just that?
Yes, that's Nelson Mandela. Many people don't know that when he became president, one of the first things he did was freed all of the women in prison who had children under the age of 12, because he recognized both he and his then wife had been jailed, and he recognized that to jail a mother was to relegate generations to come to subjugation. And so he did that. It's been since undone, unfortunately, but he did that. And there was no big increase in crime
The
rates.
world
The
didn't
world didn't
collapse.
fall.
Yeah.
Right now I described some of the MPs running around, the folks running around saying the sky will fall if we amend Bill C5. So I think anybody watching,
Yeah.
if you're looking, I know lots of people, many of you are already doing a ton of things.
Yeah.
If you only have time to do one thing, call or email or write a note to your member of parliament, and if you have time, to the senators from your area, and say you want to see the sort of amendment we're talking about. Amend Bill C5 so that any mandatory minimum penalties that the government is not repealing, they allow judges the discretion to do their job and not impose that mandatory minimum penalty. And if that's all you have time to do, that will be a huge, big help right now. And if you have time to do more, then look at the reports, look at the incredible work that you do all the time, Pam, and amplify it, get the message out. So if you don't have time to get on the phone and be calling and bugging people and it's not bugging, but nudging people like me, then send at the very least keep amplifying this message so that more people know, because we do need action, and the action comes from you. And politicians we're public servants. We should be listening to the public. And so if you feel strongly about this as we do, then let your member of parliament know, let the prime minister know, let the minister of justice know, and let the senators know.
It's such good advice. I mean, to wrap it up this way, the problem can seem overwhelming. Like people don't know what to do. They feel too distant from it. They don't know all the information. But here's the thing with basic human rights. You don't need to know everything about everything to know that people deserve their basic human rights. And their human rights are being denied in this case when judges can't even consider their situation and maybe find an alternative or a lower sentence. And so all this is doing is saying you have discretion. It's allowing them to have discretion. That doesn't mean that in any specific case that they're not going to sentence the person. It just means they're going to be able to take everything into account and hopefully have a sentence that's fair and reasonable and appropriate to the circumstances, taking into account all the circumstances. So if you can all act on that, that would just be phenomenal. And like Kim said, share all of this information, share these reports. I mean, I will provide links to all of these reports and other ones that Kim has mentioned, and the bill in the description box for this video that comes afterwards. Share this video, share it widely, send it to the MPs and senators and everyone else.
Good idea.
If all of the people, all of the human beings that are incarcerated right now know that we're working on this and we're pushing and we won't stop until we get them back home, I think that would help in some way, because governments end up listening to people. And if we can make this a big issue, if we can make it an election issue, if we can make it a policy issue, we have the power to do it. And that's why we are reaching out to you live tonight. That's why we're on Twitch. That's why we're on TikTok, to try to reach everyone where they are, to remind them that, there's human beings who are suffering, and attached to that human being, that Indigenous woman, are her kids, are her parents, are her relatives, are her community, and everyone else that will come after her to suffer the same fate. So it's really about just being loving and supportive and strong for our communities, and that includes Indigenous women. And thank you for being here, Kim. Thank you for doing this. I didn't tell everyone in your introduction, but Kim has effectively lived in prisons as an advocate. She wasn't an ivory tower. She's literally gone into prisons and advocated and worked for people. She even brought her kids or babies into prison because she knows that these women are dangerous. In fact, they would babysit her kids while she was going around and doing the advocacy part. So you're getting the real deal with Kim. She brought senators to prison. So if Kim can do that in her spot, we can share this information everywhere, and we can pressure politicians to do what's right. And thank you so much, Kim.
Thank you.
Sorry that we went over a little bit, but we are just going to keep talking about it until they do the right thing. And I'm going to do the same thing.
And thank you for your leadership. And let's remind people of just how effective your interventions have been. It's thanks to you that the Senate did make amendments to the Bill S3, which was looking at the lack of entitlement of Indigenous women to membership and to their own communities. And your educating of us meant that we were able to make an amendment and to change, and you continue to do that. When we were told by the government it had been fixed, you showed us how it hadn't been. So every single one of you can make an incredible contribution, and I want to thank you, Dr. Pam Palmater, for the incredible leadership, scholarship, education of all of your students, but all of us who are students of yours in the public as well, and for all the ways you teach and lead and inspire us to do the right thing. So thank you.
Well, thank you. And I can't wait to see everybody's advocacy on this area. And we'll be back, no doubt, talking about other ways that we can address this. Thank you so much, everyone. And that does it for tonight. Links will be in the description box below. Thank you.
Thank you. Take good care, everybody.